Good morning, everyone. Welcome to um, the National Will Week information session. Um, I'm just trying to show my video. Yes. We've had 2 weeks before of this information session, and today is the third week, followed by the next week on the fourth week. We covered last week the tested succession, and that was the week before. And last week we covered how to draft a will. Last week we covered interstate succession, and today we'll be covering how to draft a will. Today we'll be joined by our speaker who will be assisting us through that. I will introduce her shortly now. Her name is Kolofelo Sekelo. Madam Kolofelo Sekelo. A brief on her, just a quick one. Can anyone hear me? I wonder if I'm audible enough. Can anyone say again, can hear me at least? Am I audible? Yes, thank you so much. Madam Kolofelo is an admitted attorney working as legal specialist for one of Africa's largest technology companies. Wow. She's passionate about community and youth development and is a contributor to Sister-in-Law platform, specifically dealing with matters pertaining to law of succession. We're happy to have you, Ms. Kolofelo. Please welcome.
Thank you, Elisa.
After Ms. Kolofelo, quickly, before I give you the platform, Ms. Kolofelo, we'll follow a question and answer session from a lady from Legal Aid South Africa, Luna Lingani, will follow afterwards, and we will welcome her after Kolofelo. Thank you, Kolofelo. You may take the platform.
Yes. Can you guys confirm if you can hear me? Because the last time somebody in the comments said they couldn't hear me. Am I audible?
You are audible enough. Thank you very much.
Okay, thank you. Good morning. I'm just going to walk you through just the basics of drafting a will. It sounds very easy because we watch movies where people write on a piece of paper, and then somehow it becomes a valid will. Our laws are slightly different in South Africa. We have formalities. I think I'm just going to start my presentation. Let's just hold on. Still loading. Thank you. All right. First and foremost, I would just like loud and clear. Thank you, Kulfal. Okay, thanks, Zandile. I would just like to say that it's important for you to get your will drafted by an attorney. Yes, you can do it at home. I'm going to take you through the basics of just drafting your own will, but why it's important to involve a legal practitioner is that firstly, we're trained professionals qualified to do this, but other than that, there are certain regimes like marital regimes that you might need assistance on when distributing your estate. So an attorney or an advocate will advise you accordingly, tell you what happens in the dissolution of, well, not really a dissolution of your marriage, but just what happens in bequeathing certain assets to your legatees, the people who will inherit specific amounts and specific assets. You want to get the wording right. You want to make sure you adhere to the particular formalities that I'm going to list just now. You want to make sure your will is valid. And most people don't know what makes a will valid. I'm just going to take you through that. Just the next slide. Yes, just by the way, I'm representing Sister-in-Law, as Advocate Yolisa had said. You can find us on our website or on any social media platform, Instagram, Facebook, and Twitter. Just note on the will. just an intro, a quick intro. Wills are regulated by the Wills Act of 1953, as amended. This act prescribes requirements and formalities of a valid will, as I said earlier, and this is very important, where such a will was executed on or after the 1st of January 1954. So I'm just going to give you an instance where the will is executed on that 1st January 1954, but the testator dies before 1 October 1992. This is when the will was amended. So just before that, in order for the will to be valid, the will must comply with the formalities prescribed by Section 2 of the Wills Act before it was amended. The requirements are peremptory, and failure to comply with Section 2 strictly renders the will invalid. Strict application. Now, the will executed, where there's a will that was executed on or before 1954, January the 1st, and you, the testator, well, not you, but the testator dies on or after 1 October 1992, that's all of us. The Amendment Act made an important change to the formalities of the execution of wills. A will which is complete and regular on the face of it, the prescribed formalities have been complied with, is presumed to be valid until the contrary has been proven. So you can dispute a will, take it to the master, and it can be disputed in court. Just next slide. So as I mentioned earlier, there are formalities that are set out in the Wills Act, Section 2. The first and foremost, it must be in writing. Must be in writing. Forget what you see in the movies. And the will, again, the will is signed at the end of the will. There will be a signature page by the testator. So the testator is the person drafting, well, the person who is making the will, in whose name the will is under. So the will is signed at the end by the testator or some other person in his presence and with the direction of the testator. So what I mean by that, what they mean by that is that, let's say I'm not in the right, let's say I'm going through a depressive state and I need a best friend or my mother to just, or let's say I lost my hand, actually, with regards to, this is a perfect example, lost my hand and I got amputated and somebody needs to sign for me. I need to be present and direct that person. And we need to be in the presence, when signing, we need to be present in the presence of a commissioner of oath. This can be, as you know, the police, an accountant or a legal practitioner, an attorney and an advocate. The testator's signature is made, another formality is that the testator's signature is made by him or by such other person, or is acknowledged by the testator if made by some other person. Also by such other person in the presence of two or more competent witnesses present at the same time. So here's the situation. I'm the testator, and let's forget about somebody signing for me in the case of amputation of my hand. I'm the testator. I need two witnesses, minimum, two witnesses, and all three of us are signing in front of the Commissioner of Oaths. We all need to be present at the signing. The witness must, another formality is that the witnesses must attest and sign the will. But the Amending Act prescribes that the witnesses only need sign the last page. So contrary to popular belief, I've been hearing this a lot, the witnesses don't need to sign every single page like a normal contract. It's not a contract, it's a will. They just need to sign at the end on the signature page. And they don't need to know that it is a will. And they don't need to know the contents of the will. Next slide. Just continuing with the formalities. If the will consists of more than one page, each page, other than the page on which it ends, is also signed by the testator, signed or initialed by the testator. or the person being directed by the testator at the bottom of each page. As I said, witnesses only sign the last page. The definition of sign, by the way, has been amended and now includes the making of initials, and only in the case of a testator, the making of a mark, and signature has a corresponding meaning. If the will is signed, another formality is that if the will is signed by the testator, by the making of a mark or some other person in his presence, and by the direction of the testator, again, the Commissioner of Oaths needs to be present. Just know that at the signing of the will, everyone who's signing needs to be present in front of the Commissioner of Oaths. The will must be executed, signed, and witnessed in the presence of the Commissioner of Oaths, who shall then certify that the will as soon as possible after the will, who shall certify the will, sorry about that. The Commissioner of Oaths certifies the will. That is it with regards to formalities. Just next slide. Just carrying on with notes on wills before we get into the contents of a will. So just a note of this for divorcees. There's an effect on divorced or annulled marriages on the will. This is section 2B of the Wills Act. So it deems the death of a person which occurs within a period of 3 months of his marriage being dissolved by either divorce or annulment to be temporary revocation of any benefit to his previous spouse in a will made before the divorce, unless it appears from the will that the testator intends to benefit his previous spouse, notwithstanding the dissolution. So I just want to break this down. If you die within 3 months after a divorce or annulment, having left a will before the date of such a dissolution of the marriage, your now ex-spouse will not inherit from the will. Is that 3-month window period. They will not inherit unless you made it clear. It is clear that from the will that you intended for that spouse to inherit. So there's some people who don't have bad blood and they would want their ex-spouse to inherit regardless. Just moving on to other notes, competency to make a will. I see that there was a question just now that came in, so this is going to answer your question. Competency to make a will, this is now section 4 of the Wills Act. Only a person of the age of 16 years or older may make a will on condition that he has a mental capacity to appreciate the nature and the effect of this act. Next slide. Just continuing with competency. A witness or a person who signs a will in the presence and by the direction of the testator, or who writes a will or any part thereof in his own writing, and the spouse of such a person at the time of the execution of a will, shall be disqualified from receiving any benefit of the will. This, very important, this does not affect the validity of the will. So if you're a witness who signs the will, in the presence of the testator, or you're drafting the will by direction of the testator, you are not allowed to inherit. But let's say the testator put you down, the master will declare that you're not allowed, but the will itself will not be declared invalid. Another competency, another point to make on competency of person involved in execution of a will. A person or his spouse who is precluded from inheriting in terms of the above may be permitted by the court or the master to inherit under certain circumstances, and they're listed in section 4A. Can we just move on? I just want to get to the meat. So who cannot inherit? I think that's another question that just popped up. So a person who has unduly influenced the testator to give him a benefit under the will. So obviously, let's say we're out and about and I drag you and I'm like, put me in your will, or I just put a gun to your head or a knife on your neck and just force you to put me in your will. I mean, if this is proven, then I am not allowed to inherit from your will. Another person who cannot inherit is a person who is unworthy. For example, where the beneficiary murdered the testator. We have a lot of those cases worldwide where people knew they were in the will, things were not going well in their marriages or relationships, kill their spouses to benefit. Once a criminal case is established, then, and they find out that you killed your spouse, then you will not be allowed to inherit from the will. There must be blameworthiness. Another person who cannot inherit is a person who has concealed the will of the testator. Why would you do that? These are quite, you'd say that they're a little obvious, but it still has to be, I'd still have to put it out there because some people don't know. That's why people keep killing their spouses thinking that they will inherit when the marriage goes south. Next slide, please. So, what we all came here for, the contents of a basic will. I know that everybody wants to do this at home and just flesh it out, and then bam, we have a valid will. I still highly advise that you still see a legal practitioner to help you out, especially in the coming week where it's Wills Week, and there's a lot of legal practitioners who have volunteered their services to draft beautifully for you a valid will. Now, we have to start out with the heading. So it'll read out the last will and testament of Kholofelo Sekele, 1999. I wish. Set out the ID number and then cite the person, like an unmarried attorney residing at number 5, blah 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 blah. That's the main heading. Set out my details, where I'm residing. The next important, we call these boilerplates, very important clause in a will is a revocation clause, where you now cancel all prior wills, just so this one can be the prevailing will. So then you will state, I revoke all my, just in simple terms, I revoke all my previous wills. And this will now supersede any will made before. Next, next heading that you will have in your will, the next clause you will have in your will is the appointment of an executor. So I'll just set it out and I'll tell you what the executor does. You will then have to say, I nominate whoever you trust to basically administer, manage your will, make sure that this is your will is implemented accordingly. You will then say, I nominate Advocate Julissa, set out her name and all her details. Failing her, I nominate Leanda, set out her details to be, these people will be the executors. Oh, failing which, whoever, I don't know when it will fail. Let's say Julissa does not want to be an executor of a will. That's a very big task. Not everyone will want to carry out a will in the form of being an executor. It's a big ask. You have to see the will through, make sure that everything is done, go to the master. Any problem with the will, you'll have to attend to. So it's very easy for an executor to be like, I'm okay, I don't want that. So create a substitute, provide for a substitute executor. Yeah, so what the executor will do, make sure that the will is lodged with the master of the High Court, make whatever queries arise in liquidating the estate and making sure that the wishes of the testator are met, the executor has to attend to. The executor can appoint a lawyer to now administer, to do the runaround work with the master for them, but basically they're the main boss of the will once the testator has passed away. Another important clause, moving on from the executor, is the nomination of a guardian. This is very important for parents. If you or guardians, if you are a legal guardian of a minor, you should leave a will. There's just no excuse. You really should leave a will. So then one of the important clauses will be the nomination of a guardian, where you will set out that in the absence of a natural guardian, let's say the father is also not around, then I hereby nominate Nomsa. Failing her, I nominate Palesa as guardian of any minor child of mine. I direct that it shall not be necessary for the guardian to furnish security. The master requires security whenever such a clause arises, interstate and intestate succession. So this is a very important clause where you can just tell the master, no, it is not necessary for the guardian to furnish any security. The securities are very tricky to furnish the master with because not everyone has the money. Another importance of having a will where you can tell the master what to do. Another important clause is security. So this is where, let me just read out what you can say in that particular clause. This slide is very important. You can take photos or just a screen grab of the slide. Another important clause is where you say, I hereby grant my executor all the powers allowed by the law, including the power to appoint someone to administer and manage the distribution of the estate. This is now where the attorneys come in and they see the estate through with the master. And you can also further say, as the testator, my executor is exempted from giving any security to the master to do his administrative duties as contemplated in this will. The master requires security, as I said earlier, can require security from the executor and from the nominated guardian. So again, a will is important to tell the master there's no need for security. I want these people to do these particular things without security. Next slide. All right, now this is also important. Everything I've actually just mentioned is important. The legacy clause. The people who inherit under this clause are called legatees. Now, legacy is giving a specific amount of asset to a specific person, specific legatee. This is where you can bequeath, let's say you have a house, I bequeath my house at whatever you put down, your title deed details, my section, whatever, plot, whatever, to this particular person who is the legatee who will inherit. And it can be. Okay, sorry, Yelisa, did you have something to say? Okay. I think we're just having a sound problem there, but anyway, as I was saying about the legacies, there can be many legacies, but please take note of who can and cannot inherit in a will. Section 4 of the Wills Act. Again, this is why it's important to consult an attorney. So you go there with you set down your wishes, you can write them out on a piece of paper. Hi, Elisa.
I'm back. Thank you very much. Thank you. It was my connection. Could you hear me the other time?
Yes, we could hear you.
Oh, sorry. Thank you. I'm back. Thank you very much.
No
sorry
problem.
for that.
Yes. Cool. Mhlanga, we'll get to the questions at the end of the presentation. We have all your answers. I just see that somebody just asked, what do we mean by security? I'll explain again. Legacies, again, giving a specific amount of asset to a specific person. I bequeath this particular thing or this particular thing to this particular person. And now we move on to the next important clause, the heirs. So people often confuse the legatees and the heirs. So now the heirs are people who inherit the remainder, the balance of the estate. So you'll have a clause where you'll say, I bequeath the balance or the remainder of my estate to these people in equal shares. Should an heir not be alive at the time of my death, his children will receive his portion. And now the next one, the next important clause in a will is heirs to inherit free of community and accrual system. So now this is where I have to read out this clause for you, just so you can just get the crux of what it means. You as the testator will then say, I direct any inheritance bequeathed herein shall be free. I direct that it shall be free from the operation of the consequences of any marriage in community of property. Such inheritance shall also not form part of any accrual operative in South African law or any law elsewhere where a beneficiary may reside. Sorry. Any inheritance in this will shall also not form part of any insolvent estate of a beneficiary or spouse of a beneficiary. So now you're basically making sure that your heirs inherit free from the whatever marital regime that they're in, and free from and the inheritance will not form part of their insolvent estate or the insolvent estate of their spouse. Great clause to have. Next slide. Okay. Oh, at the end of our presentation. I'm so sad, but it's fine. I'm sure that we have a lot of questions, so that might help in breaking down the actual presentation. So now, as you know, next week is National Wills Week, and we have a lot of law firms and organizations who are willing to draft your will for free. This campaign is run by the Law Society. There's also Legal Aid South Africa is quite helpful. Because Lisa will tell you, Legal Aid South Africa is quite helpful. They also have templates in their website for a basic will. This is not something to just take home and sign, not knowing what's going on. You still need to consult because every situation is very different. Every circumstance is very different. Some people are married, some people have kids, some people are married in different marital regimes. So just check out the Law Society's website. It's on this slide, and Legal Aid South Africa's website. As also, so if you want your will drafted, I would recommend that you take the following to the legal practitioner of your choice. Also, the Law Society's website will tell you who's in your area that's offering their pro bono services for Wills Week. So if you choose to consult, then take the following for next week. Take your original ID or driver's license, proof of residence, any title deeds you might have, proof of ownership of all your assets, any liabilities that you may own, basically a list of assets and liabilities, income, passive income, rental income, things like that, policies. Make sure you have every single thing that you pay for, and somebody might benefit because of that payment towards that thing. And yeah, make sure you take all of that info, copy it, take it to your attorney, and get a valid will drafted for yourself. Do yourself a favor and your loved ones, especially your children. Thank you.
Oh, thank you so much, Madam Sekele. That was informative. I'm sure by now we know we definitely need a will. Thank you so much. Without taking so much time, Madam, we will move on to Miss Luna Lingani. She is from Legal Aid South Africa. She will be taking us on for the questions and answer session. So what we will do is we will go through the questions, and so that if we need questions of clarity or follow-up, I will also be just following up with those, just to assist those who are asking as well for clarity. Madam Luna Lingani, you may join us, please. You may unmute yourself. Thank you.
Good afternoon. Is it afternoon? Good morning. My name is Luna. Thank you for having me. My name is Luna Lingani. I'm a supervisory legal practitioner in the civil section at the Crossed Office of Legal Aid South Africa. So it's an honor to be part of this important project, if I may say so, as we are observing the Wills Week starting from next week. So do I just shoot to the questions, or what? How are we going to have it?
Thank you, madam.
Can you hear me?
I was just giving you time to talk. So what we will do, I will give you each question so that you may focus on answering the question. And then we can work together from there in. Yes. The first question that we wish to hear on is, what can make a will? Who can make a will? Who can make a will? So there's a person who is actually putting their interest in the will. There's the person who is drafting the will and officiating it. So who can make the will? There's a question. Thank you.
Okay. By saying who can make a will, are you saying maybe in terms of who's eligible to make a will in South Africa, or the actual drafting of the will? Because.
Thank you, madam. Thank you, madam. So to make it easier for all of us, so let's break it into the two portions that we are dividing into. Who can make a will? So first you'll explain to us who is eligible to make a will. And then the second one is who can draft and make sure that it's legal. Your will is legal and can be executed. Thank you so much.
Thank you. All right. As previously stated by Kolofelo, there's an act that regulates the will. It's called the Wills Act. So any person who's above the age 16 years and above can make a will, as long as they are mentally fit, meaning that if their mental capacity, they don't have any mental issues, they are well mentally, they can make a will, as long as they are 16 years and above, and they have good assets, because the will is where you stipulate what happens to your property or to your assets. And you must also be mindful that the assets of a deceased estate, they don't just, it doesn't allude only to the assets, it only, the estate of a deceased, it includes both assets and liabilities. I just need to emphasize that. So now any person who is 16 years and above can make a will. Then to the second part of the question, which is who can make a will. Look, if a will, if it's a simple will, I don't see why a person cannot draft their own will. If there are no complications like your fideicommisum, a person can, there are also documents that can, there's a fill-in will that can be bought at a store. Some bookstores like your CNA, they sell those fill-in forms. It's a will that is already, it's a template sort of. But if it's a complex will, I would suggest that a person can get a legal assistance from any place like an attorney. Offices of attorneys, they do draft wills. Banks, they do draft wills. Trust companies like your FNB Trust, Standard Bank Trust, they do draft wills. And some of the banks, they do draft wills provided they are going to be made executors of the wills, of the estate, sorry. Does that address the issue?
Thank you so much, ma'am. It does address the issue. We've now noticed that the testator, the person who is the testator who attests, can be over the age of 16 as long as they are mentally well. And then you explain to us that the other side, the accountants, the lawyers can do it. Thank you so much, ma'am. We captured you. The next question, if we may. What happens if a will fails? What happens if a will fails on formal requirements? There's those requirements that were outlined in terms of your signature, where it must be end of the document and so on. So if any of the requirements are making it to fail, or the formal requirements are failing, what will happen to that will? Please assist us, madam. Thank you so much.
Thank you. Remember, after the death of the testator or testatrix, the will is submitted to the office of the Master of the High Court. So if the will it fails, like it doesn't meet the formalities or the requirements to make it a valid will, it will be rejected by the Master of the High Court. And then that estate, it will devolve in terms of Intestate Succession Act as if there was no will at all. But it can also be challenged, you see, you know, I mean, if any person who's got an interest in the estate feels that maybe the rejection of the will by the master is unfounded, or they can take it to court, High Court. It can be challenged at High Court, and then they can state the reasons why the court should accept it as valid, even though it's been rejected by the master as not being valid. But I must say it's quite it's a costly exercise. So and it's also it can also delay the finalization of the estate, because everything will come to a standstill until the High Court can pronounce on whether that they can declare that will as valid.
Thank you, madam. Thank you, madam. We captured you. I'm sure we will get a raise of a hand if it was not clear from the person, but from my chair here, it is very clear. Thank you, madam. Okay. Are you ready for your next question? You're doing well. Thank you so much. The next question is the divorce.
Right.
Does divorce affect a will? Or can you explain to us how a divorce may affect a will? Right. So I'm sure then we'll in this, just quickly, just to clarify for the different, for the benefit of the rest of us. I'm sure there you will touch as well where we are divorced and it's been 3 months or more, or we got divorced today, kind of thing. Then you can touch on the base for us, please. Thank you.
I think Utebelo mentioned it in the presentation. Mm-hmm. There's a section that I think it states that if you divorce, if the divorce happens, if the testator dies, let me put it like that, within, I'm trying to put it in layman's terms, within 3 months, yes, of the will being executed, that spouse won't inherit or benefit from that estate unless the court, remember now that they can still go to court and challenge it unless the court can, or the spouse can prove that it was the intention of the deceased to benefit the ex-wife or the ex-spouse, be it a husband or a wife.
Yes, yes. So you've touched on if it's before the end of, and if it's been a long time and you're still on the will?
If it's been?
If it's been now a year or 2 years and I'm still on the will of my ex-husband, what happens? Then
in that case, you're definitely going to inherit. In a way, it gives the person 3 months to amend the will. Let me put it like that.
Yes. Very
so if they don't amend the will and it's been a year or 2 years, then it means they had no intention of you not inheriting. They put it in layman's terms.
Yes. Thank you very much, madam. It's very clear. We have our next question is the repudiation. So one of our listeners would like to know, what is repudiation?
Repudiation can be, maybe let's say, I'll make an example, if there's an executor appointed in terms of the will, and then they choose not to, they can repudiate their duties in terms of the will. So repudiation is when one of any party to a contract doesn't perform or chooses not to perform or refuses to perform in terms of the contract. That's what repudiation is. So in a will is when maybe you say that you find that the executor says, no, you know what, they repudiate the appointment in terms of the will.
Yes. Can I introduce a second leg to it?
Yes.
The second leg where exactly as you are saying, if you repudiate, and maybe now let's introduce the second leg where you are married in community of property. So if you are married in community of property, you still have most your own share. And so the repudiation of whether the estate you receive or you don't want to receive anymore will be only in respect of your spouse's portion.
Your
Is that
share.
correct?
Yes, that's correct, ma'am. It should be in terms of only your half share. If you're married in community property, you can only, whatever you do, it will be only for your half portion of the estate, of the joint estate.
Perfect. No, it's clear. So my half is still my half. The repudiation is only in respect of his half.
Half, yes.
Thank you, madam. Yes, okay. We'll go to the next question, and this is so nice because we get to capture all of it as these questions come in. We get to capture it so well. I will move to the next question if you are ready, please.
Okay, let's push.
Where to do? Yeah. Yes. Can you tell a person you're putting them as an executor while you're still alive? So now I think this person also heard, one of our viewers also heard where we were talking about you knowing about you are in a will and all those. So can you be told that one day you will be the executor?
Yes, you can.
Thank you.
And
I think
remember,
that was a straightforward one.
Yes.
Yes. Yes, ma'am.
Remember, an executor doesn't necessarily have to be someone who's going to benefit from a will.
The next question is, can I leave an RDP house to someone in a will? I guess, yeah, it's an asset.
Look, if it's got a title deed and it's in your name,
yeah,
it's an asset. It's your asset.
It depends.
Yeah.
Yes, thank you, ma'am.
Because
there's this question.
Okay.
Because yes, no, I just thought that maybe there's questions that are more detailed. So if you don't mind, I'm not rushing you, but because we have a lot of questions that are more detailed. Okay. So that one I was passing, unless you had more, madam.
No. As long as it's got a title deed, let me put it like that. Yeah.
Perfect. Thank you, madam. Also, I've heard you can have a parental guardian to take care of your kids and separate financial guardian to take care of the finances. Do we add these people to the will, and will it stand if parental guardian wants to fight for money? Okay. So I guess our an attendee here wishes to know the financial guardian and I guess the guardian. Please explain that to us.
Okay.
Before you get to the question about fighting for the money, I think there's two portions. First, just identify these guardians, then get to the money. Okay. Thank you.
Remember, if
you can see the question in front of you, madam.
No, not really. It will mean that I will have to go
so
to
I will continue.
Yes.
It's fine. I will continue like this. Thank you, madam.
There's two parts, like I said. If there's a minor child involved, you can put in a will a clause that states that you appoint so-and-so as a guardian of the child. And then that person is going to, remember, a child will have a guardian until they turn 18. That's just a normal guardian for the child. So that's one you can put on the will. Sorry. So the issue of the financial guardian is the one who's going, normally, look, there's a guardian fund. They take care of they keep the money, if I can put it like that, for the minor children. So it's always advisable that the money for the child can be, whatever it's due to the minor child can be kept at the guardian fund until the child turns 18. But if a person feels that there should be a financial guardian for the child, then it can also be put in the will as well, so that to avoid issues of fighting between the two, or for their duties not to overlap, then it can be clearly stated in the will. Remember, the will is where the deceased state or put their wishes or what should happen to their assets, or should they not be, should they die?
Yes.
Is it clear now?
Thank you. Yes, it is clear, madam. There's nothing to even ask there. It's very clear. So we have two legs there. One, it's for them just to get 18 and be taken care of. The next one is who keeps the money. Rather, get it to the guardian fund, you were saying. Thank you.
Yes, it's easier that way.
Thank you. The next question, does assets in a will, do assets in a will include pets, dishes? Yes, but that is important, you know? Yes. So,
yes, I understand. Definitely, those are your assets. Those are your assets. You want clarity on what will happen to them. If you want to give your handbag, your dishes to your grandmother, you can put in a will that I want my cupboards to go to so and so. You state everything as long as they are assets. There's nothing that prevents you from not stating that I want so and so to keep my pet, or to inherit my 2 dogs, and I want my cat to go to so and so. Because you want to avoid a situation where no one will, where people won't know what to do. They will end up taking them to SPCA. So rather put in a will.
Okay, sorry, can I just add on to that? Also, things don't have to be of financial value. So whatever, even sentimental valued things of yours, where obviously the main thing is that you have to be the owner of whatever you're bequeathing to that person. It doesn't always have to be money. I see a lot of questions about like financial things. It doesn't always, but just something that is of sentimental value and you'd like to pass it down to someone else.
Thank you.
Perfect. Thank you so much, madam. Actually, I think you'll also take some of the questions as well, just to give Ulina the breather.
Yeah, no.
So that I don't run her like that. Thank you for giving me that thought as well, just to putting it there. Thank you so much. The next question is, can alternative dispute resolution be used in wills disputes?
No.
Yeah, that's a no.
I don't know.
Especially,
I think we answered it at the same time.
Yes,
we all said
yes,
unanimous.
No. Yes,
No.
yes. No, okay, we're gonna move. It was answered. The court, the higher court, it was mentioned. Yes. What do we mean by security? So I guess that talks to the executor and all that. What do we mean by security?
Okay, do I take that one?
Please, ma'am.
All right.
Until she gives you the break, this is your baby. Now we will keep chipping in. Thank you.
In terms of an executor has to put in some security, ideally, in terms of the act, meaning that it's an amount that they have to pay in as security. Let me put it like that. But what normally happens in a will, it is important that you put a clause that states that the executor is exempted from putting any security, because now you can't ask a person to administer a will and then the next thing they have to be encumbered with costs of having to have money up front just for protection, that anything should anything happen, and for any cost that might be incurred. So that's what security means. It's the money that you put up front and deposit to the master by court. So it's advisable to have a clause that exempts the security from the executor from the paying the security.
I would also like to make an additional point that the importance of a will. It's so sad in interstate succession where you don't have a will, and your estate is administered by the master. They impose these securities, these deposits, where it's basically like a performance security that you'll only get in the end. So sometimes it's amounts that you cannot afford. So let's say I'm appointed as a guardian for, let's say in a will, I'm appointed as a guardian for the minor child, and I'm asked to, and the testator did not state that I don't need to furnish security. And then the master requires security from me. Unemployed, the master's requiring 48,000. I don't have, and it cannot go forward until I finish that security. Or I have to just basically dispute that with the master. It becomes very lengthy when the testator does not state the exclusion of security clause.
Yeah. Thank you, ladies. That's clear. I will not add anything to it. Thank you so much. Thank you. The next question is, what happens if I find out after the death of my partner that the person I'm married to had a will and I was excluded from the will? So what happens when I find out that, oops, I've been excluded from the will?
Married, which regime?
Which means that we have gonna have to make it 2 thongs because they didn't explain. So then you can explain to us. Yes, in both ways. Thank you.
Okay, let's start with the marriage. I'll take the marriage in common property. Remember, in a marriage in common property, a party can make a will, an individual will for the half of their share of the joint estate. So now it means that you just take your half and fly away in a marriage in common property. Because you already, by virtue or by operation of law, you own half of the estate. So the spouse, I would assume that the will that they did and excluded the spouse would be for their half portion of the will, of which there's nothing that prohibits them from expressing their wishes, what they want to do with their half share. Is it clear, Elise?
Yes, it's clear, madam. Thank you so much. And yes, it's clear. Thank you. The next question. Is it best to have a will accompanied by a trust?
Can you take it, can my colleague address that one, please? I need to quickly drink water.
Take a break. Thank you. Thank you. No, I could also take it there as well. Yeah.
Okay, that's fine. Yes, it would be recommended that you put your trust as a clause in the will. It would be recommended that you do that, yes. And then
especially where there are minors, I guess.
Exactly. And the trustees will then be appointed, and people will know what to do and how to operate the trust from the provisions of the will. And if you want to add to that, Advocate Julissa.
Yes, the only thing I would have wanted to add from that, and because it's very clear and straightforward as you put it, is that maybe this person who's asking is thinking, but they've got a lot of assets, their estate is quite huge. So okay, they've got an extended family and a big family, because sometimes what influences people to add a trust on that is the structure of the estate and the structure of the family and the complications of the circumstances. So those are the trusts as well that would need you to get a professional and not do it yourself, obviously.
100%, and especially when you include a trust. Don't do it at home.
Never. Yeah, no, don't try it at home. Yeah,
exactly.
Yeah, even in yes. Okay, perfect. Next one. Why do our people mostly, and especially Black communities, die without a will? I don't know if we can answer that part for ourselves. But
you know, the latest stats.
Is it because of us not understanding the importance of leaving a valid will? Yes, that ties it up, actually. That ties up the question. Is it because of us not understanding the importance of leaving a valid will?
100%. He answered his own question. 100%. We don't quite grasp the importance of it. And we just think, and we watch too many movies. But just the cracks and the importance of a valid legal will, and also just what to do for your minor children. So these are things that you would address in a will, and not just you don't want to leave that interstate. You don't want the government to handle your child.
Yes, yeah, that's real. That's real. And in addition to that, in my own view as well, I would bring in customary law into it, custom really into it.
Yeah.
Depending really in the orientation of a person and in which area of our Eastern Cape, especially if you are talking about, you know, Black communities especially, where the exposure would play part. You would find in Dobana, they still have the misconception that their son, their oldest son, will inherit everything and look after their daughters. And then their daughters will not get anything, you know, automatically be taken care of by their brothers. So we would encourage then really our listeners to really be aware that actually the Constitution brought change to that type of custom. And now in terms, there's a bare case that you know, but their advisor would advise them more, which really influenced the change in terms of you females, you know, rights to inherit and not be assumed. Pardon? And
I'm
not
saying
be
male
assumed that.
primogeniture.
Pardon?
No, I was just saying the male primogeniture.
Yes, yes. So basically, what I'm getting to is that if you fail to write a will with that misconception, the opposite will happen, because then the legislation will just, you know, be fair and distribute among your heirs and your children according to the legislation. Thank you very much. I hope that's also covered. Is it best to have, okay, we read that. Are attorneys only allowed to draft wills? And what about banks? And I think we've covered that. We have, actually. I think this question was before yes, it was who can draft, yes. Which court has jurisdiction for disputed wills? We covered that about the High Court, did we?
Yes, the High Court.
We did. Yes, we said the High Court, definitely. That's when it was mentioned that it can be costly, so rather do it right the first time when you conclude it. Afternoon, okay. Afternoon, good afternoon. What happens if you are married and you have a will? Excuse me. What happens when you are married and you have a will? Then both husband and wife are killed together. For instance, a motor vehicle accident. Okay. Do you want to take that?
Okay.
Okay, I will carry on with that. Okay, thank you.
You have
who do we have back now? We have back. Luna. Let's go back. Luna, are you back? Luna, please take your house. Take over.
No, she's been here. She hasn't left.
Oh, okay. Yeah. Luna, please help us here. So if it's husband and wife and they both are deceased, what happens?
Do they have a will? I mean, is there a joint will?
I guess you'll make it too long for us. That's what I was thinking. Yes, you'll make it 2 ways for us, please.
Where there's a will or where there's no will?
I think let's tackle where there's a will, because even where there's a will, there's still circumstances of joint wills and.
Okay. Go with it, Tebelo.
Kulufelo. No, go ahead, Luna.
Okay, if the party, I mean the testator and the testatrix, which is the husband and the wife, they both die having a joint will. The executor of the will of the estate will take the will. I mean, it's a normal procedure. It will have to go to the office of the master. It has to be lodged. The estate must be reported within a certain period to the office of the master of the High Court, and then the will will be presented there. And then if the master is happy that the will it meets the formalities and the requirements, then it will be accepted and the estate will devolve in terms of the wishes of the deceased in the will, as stated in the will. Am I leaving something? Maybe I don't know. Maybe this question is
no, that's clear. You are not leaving anything, but Ukolofelo will add some of the details that she just wanted to add in quickly. That is correct in those circumstances. You have a different circumstance, Kolofelo?
Oh, and then she covered the test date part. The other part was covered earlier in our information sessions with regards to interstate succession. So let's say those same scenario, there's no will. And now the estate will devolve in accordance with interstate succession, and the master will now distribute your estate per steps. It's called per steps. Your descent, it depends on who's alive, whether you have children. If let's say you do have children, then your estate devolves to your children. Your children will then share equal amount of the estate. You don't have children, it's different scenarios and circumstances. You don't have children, might go to your parents. You don't have parents, then it'll go to your siblings. It'll just depend who survives you. But whoever does inherit per steps will have to inherit in equal shares. In that scenario where there's no surviving spouse, both of them are gone.
Thank you, ladies. I think it's clear. So basically, whether they die together or one dies at a time, it works out the same. It all goes down to, was there a will? If there's no will, it's taken care of in terms of, yes. If there is a will, it's taken care of according to the will, basically. So it makes no difference whether they die together or one dies at a time. Now I will move to the next question. Can I assign a witness if I am an A in the same, can I sign as a witness if I'm an A in the same will? Well,
No,
yes,
unfortunately not.
But please just pick one, yeah? Yes.
The Wills Act, you can't. Witnesses can sign, if a person is going to, if you're intending for a person to inherit, don't make them a witness. Don't put it like that. The Wills Act is clear there. A witness cannot be a beneficiary or inherit in terms of that particular will.
Yes, no, thank you. It's clear. Thank you very much. There's a question that says, a handwritten will from parents acceptable?
Yes, definitely.
So I guess we can say as long as it fits the requirements.
The requirements of a valid will, it is acceptable.
Yes. Nah, yeah. So is there any cost that must be paid for the will to be drafted?
Look, like I said, okay, let me talk about our organization. We don't charge for a will. We only do the wills during the Wills Week at Legal Aid South Africa. I understand that the banks, they also do wills free of charge for elderly people above 60. That's what I've learned. Also, the banks can do a will free of charge for a person as long as that person, the bank is going to be appointed as an executor of the will. So I want to know about private firms. I don't want to talk about private firms because I don't know how much they charge for wills, But I'm just giving the options where a person will have to do a will free of charge.
Yeah, and if you go to private firms, you would have to book a consult and ask about their fees. Every firm has their own fee structure. So they'll let you know upon calling what their fee structure is like for wills.
Okay.
Yes, thank you. That's captured. Except if they do it from the 26th to the 30th of October with the firms that are participating, then they can get it for free if they run next week.
That's right.
Yes, thank you very much. The next question is, can I alter my will? Yes, ma'am,
Yes.
we're listening.
Okay, a will can be altered.
Madam.
Yes, ma'am. Look, if I can just go back to the last question. Remember you said, I just wanted to add that they have to check the website of the Legal Practice Council because not all lawyers will participate during Wills Week, but there is a list there of the lawyers that are going to be part of the Wills Week. So it will make it easier for any person who wants to know where to go in order to get a free will. You don't want to go to a practice and be told, no, you're not part of it. Okay, then to move to this one where a will can a will be altered? Yes, a will can be altered as many times as the circumstances change. as long as the person or the testator is still alive, they can alter the will. But what needs to, I need to address is altering of the will. You know, sometimes they will alter with scratching or adding in between the lines. But the important thing is whatever alteration is done, it must be signed clearly and next to the alteration. And also that needs to be done in front of the two witnesses present together at the same time.
Thank you, madam. I feel like we are captured. Yes, and just to add quickly, it doesn't have, why are you laughing at me? But just to add a quick one there, that it doesn't have to be the two witnesses who were present when it was first drafted. It can be any two, as long as it is any two, according to the requirements.
Yes, ma'am.
Yes. The next one is, can I leave my assets to a juristic person? I think we're bringing in the fact that we said we can do trusts, we can form trusts, and those trusts are going to get assets ultimately. So you can add on that, ma'am, please. Can you leave assets, or can your beneficiary be a juristic person?
You can. It can be any, yes, it can. If that's what it's who you want to inherit, it can be a jurisdiction, it can be a company, it can be, I've seen where assets went to SPCA. So yeah, it can.
Yeah. Including dogs, yeah.
Yep.
Thank you.
I've seen dogs.
So just to add to that,
yes, Elisa.
Thank you, ma'am. Just to add to that, something that we might want to keep in mind as well is when some people leave their assets and their benefits to a juristic person, sometimes they even leave it for the benefit of bursaries, you know, trust that will educate generations to come, and so yeah, and so just to have that in mind, that it happens for causes and causes, for the different causes, and for the pandemic you can leave one. Next one. Do you know recent case laws to which there was dispute in a will? This question, okay. You need to check your case law. But I mean, this person wants to know basically an example of where there was a dispute. So I mentioned the Bear case before, because really the Bear case is a 2004 case. Well, that's recent for the rest of us who are old enough to say that was yesterday. Yeah, that's a dispute right there, where there is a dispute of whether this shack that was left by a father should then be inherited by these daughters, or can it be sold? You know, so these daughters have a right to inherit. But you can add, that was just off my head. I know we have quite a list here in front of us as well.
Okay.
Please add, madam. I was just saying on top of my head.
No,
Yeah.
got it. Look, that's why I think we can, because we have to, recent one, we have to research and maybe upload, write something on the website, because offhand,
Yes.
except for that one, I wouldn't know any.
Yes.
With the, I would suggest that with the wills with the formalities, some of the cases are listed in the presentation. The formalities, some of the formalities were formed from cases. So signature, these things were dispute, Kidwell versus the estate of, you know, some of the formalities, just take the formalities of the will in section 2. And the easiest thing to do, I can't think of anything from the top of my head right now, except
no, don't worry about it, because now I'm just worried about the purpose of the question as well, not to rub it off or anything, but just to say the purpose of the question would have been maybe just to know if recently any people have fought over it. Other than that, the person can Google case law in terms of, I mean, on Google, you just put your sentence and it pops up. I don't know if maybe I'm saying it quite in the format.
It's true. You can Google the dispute. There's a
Yes,
lot of legal databases that will come up and show you cases.
yes. Thank you very much. Let's move right along. At our fees, we've can I remove a misbehaving executor? Yes, I think you can, if you are alive. Yes, can I remove a misbehaving executor? Well, the I being the testator, I assume, while you are alive, you can change and chop. But once you are late, you won't know if the executor is misbehaving. Correct me there or add, and then we can move to the next question.
Can I just add something on that, Yulisa? Also, you've got
Please,
an option.
please.
You can also have two.
Yes.
You've got an option to appoint two executors. So just in case the other one maybe decides not to accept the appointment, then the other one will take over. Or maybe
Yes.
they are unable for whatever reason. So you can have one can have two executors appointed in a will. Just to add what you said. Okay.
Yeah, and if somebody has a dispute, going back to that question, if you have a dispute and you see that this executor is being a crook, then you report the matter to the master. They'll remove the executor.
Yes, thank you. Thank you, madam. Next question. Does it also mean that drafting of a will without the involvement of a commissioner of oath, the will can be nullified? So basically, is it null if it is not commissioned?
Definitely. Look, that one cannot be overemphasized. If a person cannot sign the will by means of a mark, it definitely has to go to it must be done in front of a commissioner of oaths. And there must be what is called a commissioner's certificate attached to it. So if it's not done, unfortunately, it will not be a valid will. If there's no commissioner of oaths or there's no certificate, it's not going to be a valid will. So it's very important, that one.
Thank you. I just received a notification that our webinar will be over in 15 minutes and we only have 5 questions to carry on. Okay, we have 10, but we will cut it to the bigger ones because other questions are overlapping. Next question, I think this one is longer. My sister recently passed on and she did not have a will. At the master's court, they automatically appointed my mom as the executor, even though we specifically mentioned that she was illiterate and she had wanted me to run with the process. Now, in a situation where there's lawyers wanting from her, which she doesn't have in order to issue the letter of authority. Is this correct? I feel like there's details we don't have here, but I will just go over it again, just so you can listen to it. So the sister passed on without a will. The master gave Umama to be the executor, even though the family had explained to the master that mother is illiterate. Now they are stuck in a situation where the lawyer wants the money from her, they are saying, which she doesn't have, in order to issue the letter of authority. So basically, before the lawyer can issue the letter of authority, I think that's the question there. Before the lawyer can do the letter of authority, they need payment, and she doesn't have that money.
What payment?
Can you explain for us that money?
Yes, what money? What is it for? I mean, like you said, I think the question.
Yes, Nam, that's where I'm saying, can you explain that money to us? I think it would be lovely if the person, if it's still on the webinar, to just unmute themselves and just say, I'm here, so that we can ask a follow-up question. This one is difficult because we don't know the money we're talking about here. Are we in agreement, ladies, until the person shows up?
It's probably security for the executor. But you're right that we do need context.
We've answered that one then.
Also, another problem with this is that they said that the master automatically appointed an executor. When you large the estate, interstate, they will give you a form for nomination of an executor, and all the per steps beneficiaries will have to sign and nominate the executor. So they don't automatically nominate the executor. That's also a little
Out
issue.
of character. So will you explain
That's
to
why we
us
need
then
to
on that point, madam? So what should happen if there's a dispute? Just add on that and then we can move on. So if there's a dispute where you're saying there's a form and they can agree on it, if they do not agree and there's a dispute, they can't agree on who should, what happens?
Then the master intervenes. That's where the master intervenes and appoints the executor.
Maybe that's what happened. That's how mother got appointed.
Okay.
Now, the only question we can't get to until we get a follow-up answer is what is the money for? Unless it's for the security. Thank you.
Yeah, makes sense.
Basically, we really have captured our questions, There's the last question. I think we can take, this is the last one. What happens if you don't add all assets in the will? How will those assets be distributed?
Okay, the ones that are not on the will devolve in terms of Interstate Succession Act.
Pardon?
The ones that are not on the will, they will be distributed or they will devolve in terms of Interstate Succession Act.
Yes.
Meaning that, as explained, do you want to go through the process because if
no, it's clear. I'm just reading something that says I must stop moving. So I was like, okay, yes, please carry on, madam. I just got disturbed there for a while. Thank you. Please carry on.
So the will only apply to what is specifically in the will. So all the other assets that are not on the will, they will devolve in terms of the Interstate Succession Act. Like it will be as if there was no will pertaining to that, only to them.
Yes. No, that's clear. That's clear. Thank you very much. And we have made our time. Just a reminder quickly before we wrap up. We have a last information session. I'm just thinking of the time the webinar is ending now. We have our last session next week, the 4th session next week. I'm just logging into here. It will be on the 29th of October at 11 until 12:30. And the topic that will be attended to is the Guardian Fund and how to access it. So this was mentioned earlier that the minor child, where there's the guardian for looking after the child until they're 18, and then the money. So I think it will be a matter of interest extending to that question, the Guardian Fund and how to access it. Thank you so much, ladies, and thank you for your time and all the patience.
I have a quick question. Advocate Julissa, I just want to address with the pandemic, a quick one. I just saw a question that asked about electronic signatures. Obviously, nobody wants to touch anyone and nobody wants to be in the presence of anyone right now with the pandemic. I just wanted to make it clear that the electronic signatures are not recognized by, with pertaining to wills are not recognized. So also this takes us back to the formalities of a will. We will have to be in the presence of we'll have to be in the presence of each other, all signatory. I mean, the signatories, you, the testator, the 2 witnesses, and the commissioner of oath. Otherwise, it is not valid. So all this electronic signing of contracts that we've been doing throughout the months, throughout the year, it won't apply to wills. It's not recognized. Your will
Thank you, madam. We have 2. Thank you, madam. Before this cuts us off, we have 2 attendees who have raised their hands, and I apologize I didn't. So the first one is Chris. The second one is Mr. Njozela. We'll start with Chris and then we'll end with Mr. Njozela. Well, it says Njozela, it just deleted now. Yes. Please, can we attend to that? Chris, are you there? Chris, you have your hand up. Okay, maybe they're not. Josella, are you there? Josella, you had your hand up, please. I think it's a miss. Okay. The next one is Jacob. Jacob, you have your hand up. Jacob, can you hear us? Okay,
Yes.
the last one. Oh, yes, Jacob. Yes, please carry on. We will have Audrey. We will have Audrey after Jacob. Please carry on, Jacob.
Yes, I was asking the presenter whether please can she send us the presentation. Why I'm saying this, tomorrow on Friday, we've got a slot in our local radio, so that at least we can go and share with the community about this presentation. Can she email us the presentation? Hello, am I clear?
Yes, you are clear. Rue, will you answer that for me, please?
Yes, we can share the presentation with everyone who participated today via email.
Oh, thank you so much, Rue. Jacob, we will definitely forward it. Thank you so much. The next one is Audrey, before we get cut off. Audrey? Audrey,
Hello.
are you there?
Yes, I'm here.
Please.
Can you hear me?
Yes, take the platform, Audrey.
I wanted to clarify the question, the second last question, where the person was asking about the money and the mother being appointed as the executor. I wanted to say that normally the practice in the master's office is that when the people report the estate and the master's office finds that the assets in the estate are more than 250,000, they will normally refer the clients to a private attorney. They'll just tell them, go and seek the assistance of an attorney. And that's where money comes in. When they approach the private attorneys, the attorneys will want money from the clients. I think that's where she was talking about attorneys wanting money.
Oh, I hear you. I hear you. Thank you for that clarity, Audrey. Are you catching that, Luna?
Yes, I am, but the confusion was that they mentioned letters of authority.
Oh.
In that instance, if it's more than 252, they have to be letters of executorship. So maybe, or maybe it's just because they are lay people, they couldn't differentiate between the two. Thank you, Audrey. Thank you, Audrey.
Okay. Thank you, Audrey, for that clarity. We will have Chris. Thank you, Audrey. Chris, are you there? You have your hand up. Chris is gone. Let me thank you, ladies and gentlemen, for listening in and participating. Again, my name is Yolisa Songa, an admitted advocate and practicing here in East London. And we were joined by Kolofela Sekele, who works with so much with youth and especially with projects like this, as we mentioned earlier. And we had Luna Lingani from Legal Aid, who was really doing that Q&A session for us. Thank you so much. And we had Rue taking care of our technology there as well. Thank you, Rue. You've been quiet. Thank you for all your technology and knowledge.
You're welcome.
Thank you to our attendees who really participated and gave us the time to discuss all these issues through their questions, because I feel like the questions helped a lot. We then got to a really meaty discussion. Cheers. Bye.
Thank you. Bye-bye.
Cheers.
Bye, cool fellow.
Bye-bye. Cheers. Thanks. Good to meet you.